Good evening, everyone. I hope you can hear me loud and clear. Sorry. I'm about two to 3 minutes late. Yeah, 3 minutes to be exact. But I hope you all are okay and are doing all right. Yes, I'm feeling a little bit. I'm feeling better. I'll try to explain what happened. What happened last night. In fact, I'm so embarrassed about myself for oh boy, for what really happened, because really it was just a unfortunate thing that happened. So yesterday, if you were watching my Facebook Live, you would realize that at some point I completely lost consciousness. I didn't know what was happening or what I was saying. It was a very scary situation for me. But by the way, can you guys hear me all right? Just wanting to make sure that you can hear me loud and clear. Can you hear me clearly? If you can hear me clearly, kindly just let me know. Okay, so I'll tell you, before I go into the whole legal stuff, I'll just give you a rundown of what happened yesterday. So I know I've mentioned that I am diabetic, so I think most people that follow me on social media know that I am diabetic and that I take insulin. But what most people don't know, or what I don't really talk about, is the fact that I'm also hypertensive. So I take hypertensive drugs. So I am on amlodipine. And what happened yesterday, I did mention that I was having a bit of a headache, and some I was having tummy ache as well. So just before I started the live video, I decided I was going to take my pressure tablets. So I just opened the drawer, the bedside cupboard, and I took this packet, which at the time I thought was my amlodipine, my pressure tablets. And then I just decided that instead of taking the 5 milligrams, I'm going to take 10 milligrams because I skipped the day before that. So I was going to skip I skipped the day before, so I was going to take 10 milligrams of amlodipine. Not knowing, again, people who know me well know that I have problems sleeping at night. I suffer from like really bad insomnia. I don't sleep at night. It's so difficult for me to sleep at night. Most of the time I stay up. So I have this medication that is called Zopiclone, and it really knocks you out. So instead of taking the amlodipine, which I thought was my pressure tablets that I was taking, I took the Zopiclone, opened the packet, and I took 2, thinking I was taking 5 milligrams of the amlodipine. So not knowing it was the Zopiclone, which was this tablet that knocks you out and makes you just go into sleep, into a deep sleep. So it was the Zopiclone that I took rather than taking my pressure tablets. So whilst I was on live, the Zopiclone started kicking in. So I couldn't be coherent anymore. My speech was blurry, was slurred. My vision was blurry. I didn't know what was happening. So I knew I was not feeling well, but I kept saying, maybe something is wrong, something is going on. And then after a while, all I knew was, bam, I was gone. So luckily for me, I had to quickly delete but I saw at some point, I think before I lost consciousness, I saw people sending messages saying, Mel, are you okay? You must be tired. Can you stop the live video? I saw those things. I can remember seeing those things. But then this is exactly what happened. And then it just knocked me out right on live camera. So me, I was even shocked, because I was thinking that people were calling me. I woke up, I had like hundreds of messages. People were telling me, are you sure it's not these feminist people that are taking you to marabouts and stuff like that? And it was just crazy. I mean, I was reading the messages, and even me myself, I was scared, because I was worried, and I had people like, my family, like people that are close to me, were sending me messages telling me that, what's going on, what's wrong, can you stop the live and stuff. So it's today. Of course, after I stopped, I stopped the live video and ended it. I was just knocked out. I slept till morning, But then I woke up and I was like, no, I gotta find out exactly what's going on, because I thought something was wrong with me, and that kind of thing. So yeah, so that's what happened. Now, so I feel a lot better, even though the Zopiclone is still in my system. I still feel like today I was so sleepy and tired the whole day. But I thank God that I figured out exactly what was wrong with me, and that it was just me taking the wrong medication. I took like sleeping tablets. The Zopiclone is really strong, and rather than taking what I was supposed to take. So basically that was exactly what happened. So Alhamdulillah, thank God, I'm here. I praise God. Fit as a fiddle, and yes, so we ready to do what we gotta do and get on with things. So today was a very was another interesting day, because we saw that the application which was filed by the defense team of Bob Keita was actually, the application was not granted. It was actually rejected, per se, by the Chief Justice. And then of course we saw also the letter that was sent to the state law office, that is the Ministry of Justice, rejecting the invitation for the defense team to participate in the collection of biological samples from the baby. You all know, I don't need to mention the baby's name, but I guess if you have been following this discussion, and if you've been following what has been trending on Gambian social media space and on national discourse, you would know exactly who I'm talking about. And that was the baby that was at the heart of the rape trial of Bob Keita. And of course the baby passed away, and now the corpse is back in the Gambia, and so the order of the court was that samples should be taken, all other biological samples, and So the state now has sent an invitation to the defense to take part in this. So I saw a lot of discourse going on around. So I put my laptop. Let me put my laptop away so I can talk freely. Oops, don't fall. So yeah, so basically a lot of discussion was going around. I saw people saying why, and of course the side of some individuals who feel they are, I think they've given themselves a name. I think I don't even want to start going into this sort of Gambian feminist ideology, because after a while it would seem as if it's a full-blown attack on them. I don't have issues with personalities. I just have issues with things that are wrong in my opinion, and I feel it has to be addressed, and I go ahead and I do just that. Now, so a lot of people are saying that, or why is Bob Ketter's defense team refusing the DNA? Is the DNA not what they have been advocating for, and saying that, okay, this is what will exonerate Bob and things like that? So I saw that discussion, but I'm going to come back to that in a bit. But what I want to talk about now is what happened a couple of days ago. Was it yesterday or Monday? Yeah, no, Tuesday. It was on Tuesday. Tuesday is Wednesday, so that was yesterday. With regards to the bail application of Sena Mumbai and others. Now, this was what I was supposed to do yesterday when something happened. I don't even know, man. Oh my God! The first time I lost consciousness in my life, and can you imagine for that to happen on live Facebook Live? Oh my God! So lucky for me to have deleted that video before anybody screenshot or recorded it, because apparently they said I was talking a lot of nonsense. I was incoherent at all. So, but thank God. So that was what I was going to talk about. Now, the first thing that came out of that hearing was the fact that subsequently, before Justice Jaite proceeded to go on leave, because he did say he was going on vacation. So before he went on vacation, he did say that the substantive suit, the matter at hand, has been adjourned to I think the 5th of October. But then the issue of bail, because it's an interlocutory matter, he decided that aspect of bail, which did not, it wasn't bearing on the substantive suit before the court, that issue of bail, he would assign it or refer it to the vacation judge for it to be dealt with. So what we saw yesterday was not the substantive suit. It was not the suit where she was being tried for manslaughter. No. What was before the vacation judge yesterday was the issue of bail. The defense making an application for bail, that their clients should be released from Mile 2 where they are and be sent home. But funny enough, what I found most interesting in that bail application is the departure from the previous arguments of the defense. And now, if you're just joining me, I'm talking about the Senabu Mbai bail application. This is the analysis we're doing. This is what we're talking about. Now, rather than dwell on what they started with, that, okay, it is an offense that is bailable because the Constitution overrides, supersedes all other laws. And so even though the CPC, the Criminal Procedure Code, states that all capital offenses are not bailable. Any offense that attracts the death penalty or life imprisonment are not bailable offenses. But then they made a brilliant argument to say, initially to say that, but the Constitution provides that everybody, must have that right that they should enjoy. So bail is basically what they were trying to say was bail was an inherent right, that bail was the right of every accused person. So it was a very interesting argument. And if you looked at the discourse that was going on online, you can see all these individuals who term themselves or tag themselves as feminists were actually celebrating the brilliance of the defense counsel. They were celebrating the arguments of the defense. What I found ironical was that the same law that the feminist camp was actually celebrating and saying that Bob Keita cannot be granted bail because whatever crime that he has been alleged is a capital offense and therefore it is not bailable. But then in a twist of fate, you go back online to the same timeline of these individuals, and you see that they are now celebrating and advocating that their client should be granted bail on the same basis and on the same foundation that they argued against Bob Keita. So, Bob Keita was accused of rape. Rape in our laws is a capital offense. The reason why rape is a capital offense is that the penalty for rape is life imprisonment. And the law states that any offense that attracts a punishment or a sentencing of life imprisonment or the death penalty, it is known as what you call a capital offense. And therefore, these offenses, even economic crime was all deemed to be a capital offense because the consequences, the sentencing for that, if found guilty, if on conviction, could attract life imprisonment. So these were not bailable offenses. But I want to take you back. It has not always been like that. So let me take you back on a historical journey just to create context. It was not always like that. Now, the Economic Crimes Act, when it came into existence, I mean, this was the brain and this was the baby of Yahya Jammeh back then. So because Yahya Jammeh, at the time, and this is my opinion, I may be wrong, but this is how I've looked at it, this is how I understand it. When he goes after his opponents or goes after people that have been found wanting by the law, it was difficult because these individuals were mostly granted bail. So this crime, this offense was created and it came into existence. And because of the existence of this offense, the law was amended. It was amended. And this amendment was what brought about this issue about the death penalty, capital offenses not being things that are not being offenses, not being crimes that are bailable. So you see what was happening. So for example, which means if so for example, you saw just before the 2016, just before Yahya Jammeh lost the election. Remember, you had the former Solicitor General, Cherno Marena. They were all accused of economic crime. They were charged for economic crime. You remember Sira Walindao. These individuals and other individuals, they were all charged for economic crime. So, but because of this particular amendment to the law, that any law that is deemed as a capital offense is not bailable, they were not granted bail. So that was an easy way out, the way I see it, my understanding, I may be wrong, but it was an easy way out for Jammeh to go after his to go after certain people, because once you are charged with those offenses, then he knows Maltu will be your home for a whole while. And then we understand how our our court system, our judicial system, the criminal justice system, we understand how it works. So once you are kept in remand and you're in Maltu, the case can drag on for another unbelievable 5, 6, 7 years. So you can see the rationale behind this law. Whereas I had already explained that bail, nowhere else in the world, bail is not a form of punishment. Bail cannot be a form of punishment. And the reason why I say bail cannot be a form of punishment is because you have the principle of presumption of innocence, which is in the heart of our criminal justice system. The presumption of innocence is the heart of our criminal justice delivery system, where a person, an individual who has been accused or alleged of a crime is deemed to be innocent until proven guilty by a court of competent jurisdiction. So therefore, you cannot use bail as a punishment, because if you use bail as a punishment, it means invariably that you're already punishing the individual that has committed this offense without that individual being tried in a court of law and being found to be guilty. So for example, if you were, let's say there was no change of government, there is a great possibility that the person you knew and saw as the Solicitor General, Cherno Morena, the person you knew and saw as Sirawa Lindau, there's a great monumental possibility that they would have still been in Maltu, because the offense was deemed to be not a bailable offense. So so yes, the lawyers will go, they will ask for bail, they will keep asking for bail, but the application for bail was being rejected, left, right, and center. So they would have been in jail. And this is how that law came into being. So this is why we have always argued, and we have continued to argue, that you cannot have a law that seeks to impose a punishment on a person in one hand, and then on the other hand, you are telling that person that you are not guilty, you are innocent, until the court finds you guilty. But if that is the case, if for example you're saying that Bob Keita now has to enjoy the presumption of innocence, but then you're saying Bob Keita, his freedom has to be curtailed, his movement has to be curtailed. You are saying that Bob Keita does not have any say, and he has to be in Maltu, he has to be remanded. That is a punishment. There is no way you can argue that that is not a punishment. So if that is a punishment, how then do you equate the presumption of innocence? So for example, people will tell you that there are individuals in remand who have been there for 5, 6, 7, 8, 9, 10 years, and they have not been tried, or even where they have been brought before a court of competent jurisdiction, their matters are still lingering, it's still in limbo. So these individuals are there locked up. That is punishment already. So these individuals don't enjoy the presumption of innocence, because most of the time, you would realize that if they had just gone through court and pleaded guilty, the sentencing would probably be lesser than what they are now serving or doing, not serving, because they're deemed not to be prisoners, they're just remand prisoners, they call them. But they're there probably even longer than the sentencing that would have gone with the alleged offense. So this is what we have been arguing. This is what I have been arguing. And this is what the few people that term themselves as feminists, this is what I've tried to explain to them. But they seem not to understand. In fact, when I tried to explain this position, they got all the lawyers they invited to their show. They gave a different interpretation of the law to say that yes, rape is not a bailable offense in the Gambia. And they went on to make funny jokes, and they were writing stuff, oh, the real lawyer has spoken. But in a twist of fate, they are now on the other side of the law, facing the same ramifications, the same repercussions that Bob has been facing, and what we have been advocating that is wrong. So now all of a sudden, the offense that Zainabu has been alleged that she is charged with is a non-bailable offense according to that same law that the feminists were quoting for Bob. It is a non-bailable offense. So ordinarily, they shouldn't even go to court. They shouldn't even ask for bail, because they have been advocating on one side, on one arm, in one breath, that the offense is not bailable. But then now all of a sudden, because they are on the other side, they are now saying that really, the client should be granted bail. Now, let's go back into the bail application. So rather than the defense, we saw the defense make arguments such as, there is no charge before the High Court, and that as far as they were concerned, their clients were not accused persons, that there was nothing before the court, so the clients were being held, that they were being detained illegally and arbitrarily, and that this shouldn't happen. So this was the line of argument that they had. But all of a sudden, we saw the defense now making arguments such as, and bringing human rights into play. So we saw the counsel for the defense, the applicant who was being represented by Sagar Cecilia Thomas, making a passionate plea to the court by saying that the rights, the fundamental rights of the accused persons was being violated. She went on to say that the accused persons were in one of the worst places on planet Earth. In fact, that's why I want my laptop, because I want to read verbatim her words to you. But she did say that Mile 2 is the worst place to be on planet Earth. She even referred the court to Gambia's obligation under the African Charter, African Human Rights Charter, to show that the state of Gambia, has got obligations on its nationals. So this was the argument that we saw yesterday, talking about how Mile 2 was not fit for purpose, how some of the clients were ill and not feeling well, and that they were in detention in Mile 2, and that really that is not the place for them. So this was the argument we saw. However, I don't quite understand how, rather than go into the heart of the rationale for seeking bail, which really ordinarily I would feel that they would go into the heart of section 99 of the Criminal Procedure Code. They would then go into the Constitution and then make legal arguments to show cause to the court that the constitutional provision supersedes and overrides that of an act, that of the CPC, which is a subsidiary legislation. But we didn't see that. We saw them make a very robust argument on how Mile 2 is and how bad Mile 2 is. But then you see the feminist camp celebrating this argument. And this is what makes me wonder whether these people are either dyslexic or they suffer from some sort of temporal amnesia, or is it Alzheimer's? Because honestly speaking, it does not tell well when a person would advance such heated and passionate, arguments. And all of a sudden, Bob has been in jail for like close to 2 years. 2 years. He has been in that same inhumane condition in Mile 2. Now you're making that argument that Mile 2 is the worst place to be on planet Earth. Now, just think about it. Think about it. If the High Court, if the judge was to entertain this argument to say that yes, Mile 2 is the worst place on earth, therefore your clients cannot be in Mile 2, what happens to every other Gambian that is in Mile 2 right now? It means you're opening the floodgates. Then everybody in Mile 2 will get a lawyer, they will go to court, and they will invoke that same judgment, that same ruling that the High Court has given, to say that Mile 2 is not fit for purpose, and that they shouldn't be there, and that it is the worst place on earth. So that is why these are I've always said that these are phenomenal lawyers, but I was shocked at the line of argument of the applicant, because honestly speaking, if a ruling is given where bail is granted, you already have one issue. One issue that you have is that the offense, as they have propagated, is not a bailable offense. That is one issue. The second issue is, so if you grant bail, you're causing wahala in the country because you've already established that it's not a bailable offense. It is for that reason that the bail of Bob was revoked and the guy was sent to Mile 2. And if you now want to go and now grant bail to these sets of accused persons, you're basically telling the whole world that these individuals are above every Gambian. Their lives are more precious than the lives of every other Gambian. That is what you would be saying invariably. That is the message that would be coming out of the judiciary. This is the message that they will be sending loud and clear, that, hey, you know what, Bob, your life doesn't matter. Your life is not guaranteed in the Constitution. Your dignity, your human rights, self-respect, everything, you name it, it doesn't matter. But Zainabu and her brothers or family friend, oh yes, they matter. This is what would come out. And that is why they say that the scales of justice has to be equal. The second bit is this argument on the human rights of the alleged accused persons, of the accused person. Now, if you say, the issue of them being there, not having sanitary towels, the place is mosquito infested, but every other Gambian is being sent to the same place. Every other Gambian is being sent to the same place. The applicant herself was celebrating, she's on TikTok, celebrating when her ex-husband was sent to that same place. And all of a sudden, in fact, if I were the defense, just to make the courtroom, the deliberations, the argument more colorful, I will go and bring those TikTok videos and play it and ask the court, ask the court's permission, seek leave of the court and play them, where she celebrated that yes, my ex-husband, now the father of my kids, is in Mile 2. Yes, She celebrated that and went on to say that he will rot in prison. And he has been there for 2 years. And now you come to court and you want to make the applicant is making the argument that Mile 2 is not a place for human habitation. So is Bob Keita not human? You see how the twist of faith can change things. One moment, this individual was on the other side of the law. This individual showed no sign of empathy towards the ex-husband. Now, remember, this is an individual who has not been found guilty by a court of competent jurisdiction. This is an individual who, as we speak, relies on the presumption of innocence. But it was celebrated when this individual was there for 2 years. You've only been there for 1 week. You've only been there for 1 week. And you are crying passionately, saying that your fundamental human rights have been violated. Now, if the courts go on to say yes, they agree, they buy the argument of the applicant, that yes, their fundamental human rights have been violated. Yes, the place is mosquito infested. Yes, the place is the worst place to be on planet Earth. That it is bad, it is smelly, it is damp, it is ugly. I mean, it was described in the most gruesome manner. And you wouldn't say they were lying. They were not lying, because this is a known fact. Every single Gambian knows. If they don't know, they have heard. If they have not heard, they have seen that Mile 2 is not a place where anybody would want to be at. But the question that should be asked is, what has been done about it? What has been done about it? We all saw the TRRC proceedings. We all saw the visit to Mile 2 by the former Minister of Interior, Mai Fati. We saw the public pronouncement how Mile 2 will be broken down. We saw it. That Mile 2 is not fit for human habitation. But what happened? Nothing was done. The applicant's lawyers are aware. They know the situation in Mile 2. But nothing is being done. The judicial officers, judges that keep sending Gambians to Mile 2, they are aware of how Mile 2 is. They know. Some of them have even been in Mile 2. Some of them have been locked up by jamming. They have been in Mile 2. They know exactly how Mile 2 is. But once they come out of Mile 2, the appetite is not there to rehabilitate the place. We have seen this present government had made very, very grand pronouncements on how Mile 2 would be rehabilitated. It was on the core agenda of government. But all of a sudden, the appetite is not there no more. So every single Gambian is aware of the dire situations in Mile 2. They know of it. The court is aware. In fact, what the applicant was doing was preaching to the choir, because the court is fully aware of the gruesomeness of Mile 2. But yet still, for some strange reason, the defense chose that line of argument. I wouldn't think that was the best. But who am I? Who am I? Again, if you remember, I talked about, and I gave a story about the what's the name of the book again? Ola Rotimi, The Gods Are Not to Blame. And you wonder, and you look at everything that is happening. And for me, I keep wondering, why would such a brilliant lawyer, I mean, hands down, Sagar is one of the best. But then I was shocked to see that, in fact, the State Council, MB Sow, in one of his reply, he mentioned that. He said that what the affidavit that the applicant has deposed to and the arguments of the applicant were like night and day. That rather than the applicant sticking to the arguments that she has deposed to in the affidavit that was before the courts, she was talking about fundamental human rights. She was talking about the rights of the accused persons. But then that is a very problematic argument in a court of law where other Gambians are going through the same process. So it's either you are saying that this set of Gambians, these sets of Gambians are more important than the other Gambians that are there. Or you are saying, okay, open the floodgates. I will give a ruling. I will buy your argument of the fundamental rights of Sainabu that is being suppressed, that is being violated, that's being abused. And then, yes, go home on the basis of this. And then I will open the floodgates. Wallahi, you know now we're complaining about the slow pace of the court system in the Gambia. Can you imagine where every single person in remand, my two prisoners, will now have lawyers? I mean, Gambian lawyers will be the one who will be lucky because they'll be making a lot of money. Because the courts will be inundated with people who are also claiming that their fundamental human rights are being violated by virtue of the fact that they're in Mile 2. Yet again, you saw how this was celebrated. Celebrated. And this is why we keep advocating and calling for a justice delivery system that is equal. A justice delivery system where today, if that justice delivery system had looked at the issue of Bob Keita in the manner that it should do according to law, in a manner that is consistent with the presumption of innocence, then you know what would have happened? Sainabu would have been charged, but she would have gone to court and she would have been granted bail because the law was equal. Because the law was equal. But a precedent has been set. And the thing is, Sainabu is no stranger. Because Sainabu was at the heart of the Bob Keita trial. And all of a sudden, Sainabu is now on the other side of the law. So all eyes are on Sainabu as well. You cannot take away these things. You can't take it away. You can't tell Gambians to shut their eyes and ears and not pay attention to what is going on. They are cognizant of the fact that Sainabu is now, she probably holds some sort of celebrity status in the Gambia. My nieces in England, randomly are calling Sainabu Mai. They know who she is. When they were asked, but who is Sainabu Mai? They said, Sainabu, Bob, Keita. They know because everybody is talking about it. They hear me talk about it every day, morning, afternoon, and night. It's gone international. It's not Gambian anymore. People, not Gambians, are talking about it. But if we had advocated for a system where just because a girl child or a woman alleges an offense does not make it true, and therefore you will avail the accused person the presumption of innocence, then today Sainabu Mai would have been availed that same right, that same presumption of innocence. But the presumption of innocence with respect to Gambia's criminal justice delivery is non-existent. It is just on paper. Because traditionally, the system is such that once a person is accused of a crime, you spend the rest of your life fighting to prove your innocence, because you've already been found guilty by the system. Theoretically speaking, the presumption of innocence is there, but in all practical terms and approach, it doesn't exist. So the same people that were calling Bob, the same people that were calling Bob a rapist, they had already convicted him. They had already tried him in the court of Facebook and public opinion. They were calling him a rapist. But you dare go to them and call Sainabu any name. Call Sainabu a murderer, or call Sainabu somebody a manslaughter, or whatever you think, whatever adjective you do. You dare do it and see how they will come at you and attack you. Because as far as they are concerned, Sainabu deserves and relies on the presumption of innocence until found guilty by a court of competent jurisdiction. You see how the yardstick that they use to examine Sainabu, the lens that they see Sainabu, is radically different from the lens that they will see Bob. Bob is alleged of an offense. He's an accused person. He is a rapist. Sainabu is alleged of an offense. She's an accused person. No, she's a beautiful businesswoman that continues to thrive and continues to add to Gambia's economy. How hypocritical. This is what we're talking about. The double standard. You brand one as a beautiful businessman. A businesswoman, rather. A hardworking mother. A mother of two who did all she can to save the life of a child. You sell her to the world as the perfect mother. A perfect mother that is only reacting to bullies on social media. A perfect mother, a perfect human being, a thriving businesswoman that is only being the way she is because Gambians have gone out against her. But on the other hand, an alleged person, Bob Keita, is wicked, is evil, is bad, is mean. He's a rapist. He should rot in jail. And when I tell you your advocacy is false, you cry foul. And that is because your pronouncements, what you have said, what your receipts don't go together with your actions. Because today, we should not have been here talking about Sainabu fighting for bail. We shouldn't have been here talking about Bob being in detention for 2 years. Because the law should have been in a manner that is consistent with what is written as the applicable law. And that the presumption of innocence is a right that every accused person is availed. And therefore bail can never be used as a means of punishment. Rather, the rationale for bail should always be there and should always be left at the discretion of the courts, of the judges. Because every circumstances should be looked at from that peculiarity, that peculiar situation, that unique circumstance of the situation at hand. You cannot have a blanket law that seeks to address circumstances and situations that are radically different. And this is what we have right now in our criminal justice delivery system. This is what we have in our judicial system. We have a law that seeks to invoke equality in things that cannot be equal. A law that seeks to invoke the same sense of positioning in something that is radically different. And that is why you will see an accused person who is being charged for manslaughter, which is an accidental occurrence, being denied bail. An accused person who, as far as the law is concerned, she's charged for manslaughter, is an accidental death. Manslaughter is different from murder because murder is deliberate. Murder is something that is planned. whilst manslaughter is accidental. Now, you see an accused person within a justice delivery system fighting for her freedom just because of an occurrence that is accidental. But this is only happening. This is only happening because some segment of society made the choice of being dishonest, made the choice of being hypocritical, made the choice of using the law as a means of punishment to go against people that they don't like. But what we do not know most times is that the hole that we dig, the grave that you dig, you keep digging and digging. You said, yes, I dug that hole for somebody. But invariably, you were digging that hole for yourself. You want to talk about karma. This is the height of karma. It is the epitome of karma. Who would have thought 2 weeks ago when they advocated and said, no, let Bob continue to rot in jail because the offense is a capital offense. It is not bailable. I am hoping that they would still have a live program, a show where they will invite lawyers again to come and talk about how Sainabu cannot be granted bail because it is against the law of the Gambia. And it is for that reason I found it very quite interesting when the State Council brought the attention of the court. The State Council said to the judge, he said, look at the accused persons. He said, see how fresh they are. See how fresh they are. He said, do these individuals look like their fundamental human rights are being violated? Do they look that they're suffering? Do they look like they're suffering in Mile 2? For me, that was the height of it. That was the height of it. That can only happen in a situation where you created something like this. Ordinarily, Sainabu should not be in a court fighting for bail. Sainabu shouldn't be fighting for bail just because there is it is deemed to be a capital offense. It is deemed to be unbailable, an unbailable crime. Even murderers, mass murderers in progressive war are being granted bail. The bail conditions may be stringent and very strict, but they're being granted bail. And this is what we're talking about. So now, tomorrow is the ruling. Of course, and let me tell you something. For me, the height of yesterday's arguments was when the State Council called the attention of the court and referred them to the Court of Appeal's judgment on the revocation of Bob's bail. If you don't believe in God, I don't know what will make you believe in God anymore. Can you imagine the State Council in a dramatic fashion, spectacular delivery of his argument? He referred the court to the judgment, the ruling of a higher court, to say to the judge that I refer you to the ruling of the Court of Appeal, which is a higher court. on the Bob Keita ruling for bail, where his bail was revoked. And can you imagine the feeling while Sainabu sat right there in that courtroom, and the authority, the precedent, the law, the ruling that was cited in the argument for her denial of bail was the one taken from her ex-husband's revocation of bail. Gambia, I don't know if you know what I'm talking about, but these things have never happened in our country. Never have we had a matter, a case so intertwined. Never. It is a teachable moment for every single individual that is watching and or is paying attention to this matter. It has never happened. Never has it happened. In a sudden twist of faith, the protagonist, the individual that was propagating that Bob will be in jail forever, this was her advocacy, and the people that support and surround her. That Bob should rot in jail. That there is nothing that anybody can do to see that man out. That the day he comes out of mile 2, it would be his dead body that is being taken off to be buried. This is what she said in her own words. This is what she said. And I'll tell you something today, and I want you to mark my words. I know a lot of interesting things do happen in Gambia. I know that Gambia is one country that is full of surprises. But I'm telling you this now, and I want you to pay attention to what I'm saying. Today, I am going to be a legal marabout. Hang on, there's something I need to do. 1 second, hang on. There's something I need to do. 1 second. Let me see if I can find it. Just wait 1 second. Okay, so I've done that. And I'm cool. So just somebody that was distracting me. I've just blocked that number. Now, I'm going to tell you one thing now. And take it as my legal soothsaying or legal marabu or whatever you call it. But I believe personally, if there are no surprises whatsoever, and if it is based on the law, there is no way under the sun that Sainabu will be granted bail tomorrow. Find your pencils and write this down. And I'm going to give you my reasons why. And I'll repeat what I just said. That there is absolutely no way, as per law, as per rules and regulations of the courts, recognizing the hierarchy of the courts, I'm saying there is no way that Sainabu will be granted bail tomorrow. One, I'll tell you why. You see, the Court of Appeal ruling that revoke the bail of Bob is binding on the High Court. That ruling is binding on the High Court because the High Court is a lower court to the Court of Appeal. And the ruling of the Court of Appeal is absolutely binding on the court below, on the High Court. So it will mean that if the court is granting Sainabu bail, they are going to be challenging and disrupting the hierarchy of the courts, where the precedent of the superior court is deemed not to be binding on the lower courts. That is basic law. So I am telling you with all authority that I know within, except there is magic. Except there is magic. Except there is magic. The Court of Appeal ruling, is binding on the High Court in the issue of bail with regards to a capital offense. And let me tell you this again. It is only the Court of Appeal that can grant Sainabu bail, or the Supreme Court. But the other argument that I found very interesting, but I do not want to speak on that, because if I speak on that, I just don't want to speak on that. And that is the argument about the bill of indictment that is not before the High Court. It is something I don't want to talk about, because I want to talk about, because the sad reality is that, and I'm not saying this because I'm bragging, but the sad reality is that most people pretend not to watch my live videos or even give a hoot to what I say. But I tell you they are, and there are a lot of people that are watching. I'm not just telling you just anyone. There are a lot of people that are watching. So I'm going to keep that argument to my chest for now. But I am saying this again, that except we see another drama, we do see dramas that come out of our court sometimes, but I don't see how she will be granted bail, because the ruling of the superior court is binding on the lower courts, and they must follow. This is my view. That is my opinion on that. So the bit about the bill of indictment, I would have thought that was where the applicant should have drummed and gone on. But like I said, I don't want to talk about it. I don't want to talk about it now. I choose not to talk about it now. So let's move on. I think I've done substantial justice to the Sainabu my bail application. And the one part of that I don't want to talk about is a bit about the charges not being before the court, and about the charge sheet not having jurisdiction in the High Court, and where it stopped in the magistrate's court, and the order of the magistrate not ending when the matter is before the High Court. Those are legal arguments that we can play with. Because for example, I'll just give a tip. I'll just give a little tip for something that you guys can think of. The argument of the defense is that the charge sheet of the police does not have any prominence. It's not relevant in the High Court. And they also went on to say that the order to remand stops where the case comes before the High Court. If you look at these two arguments, it's like they juxtapose themselves. Because if you are saying that there is nothing before the High Court and these individuals are not accused persons. There's nothing before the High Court. Nothing is before the High Court. You're just simply there because you have to be there. But technically, there's nothing before the High Court. If that is your argument, how then can you argue that the order of the magistrate court is no more and has ceased because now the matter is before the High Court? You see that argument? You are saying in one hand there's nothing before the High Court. And then you're saying that the order for remand, once it gets to the High Court, once it refers it to the High Court and the High Court seizes jurisdiction of the matter, that order for remand ceases. It becomes non-existent. But if you do that, then you're acknowledging the existence of the matter before the High Court. If you make that argument, you are recognizing the jurisdiction of the High Court on the matter. So you therefore cannot continue to say there is nothing before the High Court, because in one breath you have recognized the jurisdiction of the High Court and that the matter is before the High Court and that the High Court judge is seized of the matter, and that is why the order for remand does not exist anymore. Because if nothing is before the High Court, then that order subsists. Because that order will subsist until the High Court is seized of that matter. But if you say that the High Court is not seized of the matter because the bill of indictment is not before the High Court, then it would ordinarily mean that the order for remand still exists and still subsists. But this is a legal debate I will keep for another time. We'll deal with it later. Now, let's move on to the next topic, which was making the rounds today. And that is, why did Bob's defense lawyers reject the invitation to take part in the extraction of the DNA samples? Now, a lot of people are saying why? Why? But let me give you a simple answer. A simple answer. Now, I want you all to remember that an order was made where Bob Keita and the alleged boyfriend were asked to be transported to the Royal Victoria Hospital and blood samples from them taken. Now, when that order was made, the order, I will repeat, the order asked that Bob Keita, the accused person, and the boyfriend of the alleged victim be transported to the RVTH to have their blood samples taken. This was the order. Now, when that order was given, the defense, Bob Keita, objected. And not only did they object, and their objection was overruled, but they also informed the court that they had made an application before the Court of Appeal. The Court of Appeal, which is a higher court. So the lower court, the High Court, rejected the objection. They refused the objection of the defense with regards to that order. Now, when they refused, they went to the Court of Appeal, which is the big brother, the bigger brother of this court. to say that, hey, go check your little brother. We believe what your little brother did is not right. We don't believe what he did. We don't believe the way and manner by which he accepted and entertained this order and which he gave this order. We don't believe in it. We don't think it is right. And you as the big brother, you know better. You have more experience. You are more learned. And it is not only you, it is, it is the big brothers, you can say. So the defense informed the court that we have gone to the big brother and we are waiting for the big brother to say whether, yes, we have to respect what you have said and that what you have said is right, or that you were wrong. And then we will hear what the big brother say. Now, the younger brother, that is the High Court, said that no, we are not going to listen to you. Yes, go to big brother. Go to big brother. But as far as we are concerned, as far as I am concerned, I have said my word, and until big brother decides otherwise, my word stands. So here you all, go ahead, go take him, run down, go get the blood samples. Now, the state now wrote to the defense to invite them to go and respect that order of the lower court. Now, the reason why Bob's lawyer have rejected that invitation is that if they go and observe, it means they are respecting the order of the little brother's court. It's like they are taking part and telling the little brother that, yes, we agree. And therefore, their complaint to the older brother would not make sense anymore. Why would you go and complain to the older brother to say that what your little brother did was wrong? What the High Court did was wrong. We don't accept it. We reject it. We don't want it. We don't think it was done according to law. We don't think it was done in a manner consistent with law. You've gone to the big brother to say that. And then all of a sudden, if you go now and you partake in what the High Court have said, then what is the point of going to the big brother? What is the point? So what if you go and partake with everything now? Then the big brother will say, there's no more wahala. You have done it. Let peace prevail. You guys carry on. I don't know if I've tried. This is the simplest way I can explain it for people to understand. They are saying, no, we are not going to take part. Because if we take part, we are giving legitimacy. We are legitimizing the whole process and saying that we agree to it. Whilst we do not agree to it, and we have made an appeal at the Court of Appeal, let us wait for the outcome of the Court of Appeal. If the Court of Appeal still says that, yes, we have to abide by the order, then we can go and do whatever it was that we should do. But we will not go now and obey everything and then go back to the Court of Appeal to say that, oh, no, we cannot do that. Because the Court of Appeal will look at us as stupid and idiots. They will look at us as we are wasting their time. You don't go to the Court of Appeal to make noise, to say you don't agree, to say they are wrong, and then you go and sit down now and say you're partaking. No, you cannot do that. And this is why they have rejected the invitation. Nothing else. They are advocating for the procedures of the law to be followed. That yes, the big brother said he wasn't going to listen. He said he was going to go ahead and do whatever it is that he thought he has done that is right. But the law has provided where you would go to the big brother and ask the big brother to review what the little brother has done. And to argue and to make case to show whether what the big brother did, yes, was indeed according to law, it was right, and therefore the order should be followed, complied with. So this is what has happened. Because, remember, that Bob's lawyers were not present when the previous order was being carried out. When the blood samples from Bob were being drawn, they were not there. Because they refused to legitimize the process. And now remember, they don't know who kept those blood samples. They don't know if the blood sample of Bob has been switched to the boyfriend or the boyfriend to Bob. They don't know. Even in progressive countries, this happens as mistake. Samples are switched. Accidentally. So you don't know. Because it sometimes make you think, why all of a sudden blood samples were required to be taken at the same time with the boyfriend? Why? What's the rationale for that? In fact, in one of my many lives, I said the boyfriend could have rejected that. He could have refused. If he had a brilliant lawyer, he could have gone to court to say, I'm not part of this process. Why are you subjecting me to that? That is a violation of my fundamental human rights. And I have always questioned, I have always wondered why was it necessary for the blood samples of Bob and the boyfriend to be taken together? It has always baffled me. They could have ordered for it to be taken in different days, on different days. Or you don't have to take it at all. He's not the subject of litigation. He's not the subject of a matter. There's no criminal charge against him. He's not been charged. Why are you subjecting him to the process? Why are you subjecting him to the process? Some people can make the argument that the only reason why he's being subjected to that process is because there was a deliberate attempt of wanting to have the blood sample switched. Anybody could do it. Anyone could do it. We know how the hospital is. We know how the hospital is when it comes to things like that. Who is the keeper of the blood samples? Is there an order from the court to state how those blood samples should be kept? Is there an order from the court that showcased how the blood samples should be delivered to the DNA testing company? Is there any further directives with regards to that order aside of the collection of samples? The order does not say how these things should be managed and done, and under whose supervision. Under whose supervision? Absolutely, there has to be a chain of custody. There has to be a chain of custody that is followed to the letter. If there is a break in that chain, if there's any break in that chain, those samples cannot be used as evidence in the court. Ordinarily, it shouldn't be. It would not be done here in England or in America. It should be a seamless, what they call a seamless chain of custody. From the collection of the blood sample to how the blood sample is kept, how it is labeled, how it is transported to the lab for testing purposes, and how it is returned. It should be a seamless chain. And every single individual in that chain must be bound by the order of the court. This is what is done in other countries, because the possibility of tampering with that evidence is very great and very likely because of the absence of the judicial officers in the processing of these things. So you cannot just accept blindly, and people are saying, oh, well, why Bob is not doing it? Oh, let's go. No, I have advocated that it should not be done. It shouldn't be. And if it has to be done, it has to be done in a way and manner that is watertight. Watertight. There cannot be left a single room for manipulation. No room. And I absolutely condemn in the strongest of terms the collection of those samples together at the same time in the same lab. There is nobody that can convince me otherwise. I vehemently, and I'm saying this now loud and clear publicly, that the collection of the blood sample of Bob Keita at the same time with the boyfriend should never have been done. The only way that you can authenticate this process is to have a parallel sample taken and a parallel lab test done by a different and independent party, totally different, radically different from the first one. Radically different. An order should be given where the blood sample of Bob would be taken in another place and time, not at the same lab and place, where the people, the officials that are handling the blood sample of Bob have nothing to do with the handling of the blood sample of the boyfriend. Absolutely, this is a very contentious matter. You cannot leave a single room for doubt. Absolutely. So this is the reason why the invitation to partake and be part of that process was rejected by the defense on the basis that an appeal has been launched, has been made, and therefore they wait for the outcome of that appeal. And in any attempt at taking part in the process would legitimize the process, and it would invariably render redundant the appeal before the Court of Appeal. Now, we go to the last and final part, which is the bit about the rejection of the Chief Justice with regards to the application for the matter of Bob to be brought before the vacation judge. Now, I have been trying to do a bit of a research on the different pathways where a party, an interested party, can make an application of such nature to be brought before a vacation judge. One thing is clear. One thing is clear, and that is, excuse me, that is the fact that the Chief Justice, all matters of such nature should go to the CJ, and it is the CJ who will then give instructions for the matter to be assigned, of course by the registrar, to a particular judge. However, there has been consistent practice where one of the pathways, one of the route to having a matter brought to a vacation judge is where the application would be made to the substantive judge himself. And that substantive judge would grant the application. So I'll give you an example of what I'm talking about. So the substantive judge in the Bob Keita trial is Justice S.M. Jallow. Now, the defense could have made an application before Justice S.M. Jallow that even though he is going on vacation, he can assign the matter to the vacation judge to handle that matter. Now, I'll give you guys an example of what I'm talking about. You see, when Justice Jaite mentioned that he was going on vacation, he said he was going on vacation. He said he would adjourn the substantive matter of Sainabou Mbye to October. However, he said the bail application, he would assign it. He would allow for the bail application to be heard by the vacation judge. So you see, that process did not go to the CJ. The application did not go to the CJ. The substantive judge himself made a ruling that the bail application would go to the vacation judge. I hope I'm making sense. I'll repeat again. There's two pathways to getting this application, the certificate of urgency being filed, and it being granted. The first one is where you would make that application to the judge, the substantive judge where the suit is before, where the matter, who is hearing the matter. So in the case of Bob, it is Justice S.M. Jallow. So you would make the application to Justice S.M. Jallow, and Justice S.M. Jallow would then say, okay, fine, yes, the matter can be heard to da-da-da-da-da. Now, what happened in the Bob Keita trial is that Justice S.M. Jallow said that he would not entertain that. He said he would not entertain that. That means he refused that. So because he said he wasn't going to entertain the application, and that if the application was made that it would not be granted, he said that. He said if the application is made, it would not be granted. So therefore, the defense did not make the application to S.M. Jallow, to Justice S.M. Jallow, because they were already of the view and opinion that it would not be granted because he has stated so. Now, the only other pathway, the only other way was to make an application to the Chief Justice. And where the Chief Justice would grant this application, then the Chief Justice will assign the matter to one of the vacation judges, which is we had 3 vacation judges. So either of them, the matter would be assigned to them. But if the matter is assigned to the vacation judge, and the vacation judge is not comfortable to take on that matter, he or she can then revert back to the CJ or the registrar to say that they were not comfortable in accepting that matter or hearing that matter. So in the case of Sainabou, we did not see an application going to the CJ for the CJ to accept or not accept. No, it was right there in Justice Jaite's court that the matter was adjourned for a bail hearing. Dates were set and given and agreed upon by the parties. But this was only with regards to the interlocutory matter of bail. Now, Bob could not have that one pathway because the judge had said no. So the only other pathway that was left was for the judge to, for Bob, defense team, to make an application to the Chief Justice. Now they made an application to the Chief Justice, and the Chief Justice said no. He said as far as he is concerned, he feels that the matter has come to such a position that it would just make sense for the substantive judge to continue to hear the matter. Now, I made a post today where I say, to be honest with you, I absolutely agree with the CJ. I absolutely agree with the CJ. Because it wouldn't make sense to me at this stage of the proceedings for another judge to come whilst the defense will now be opening their defense. They will be opening their defense, and Justice S.M. Jallow would not see, because sometimes, remember, these cases are not just a matter of opening a defense. You're looking at the demeanor of the witnesses. You're looking at the demeanor of the witnesses. You're looking at how they're acting. You're taking notes. You're looking. You're looking at the cross examination that will ensue. You are looking at the questioning, the examination of the witnesses. You're looking at how the witnesses are delivering their accounts of what happened or what did not happen. And the vacation judge has every right and power as the substantive judge. So you could have an issue where you can have a vacation judge that can absolutely go against certain orders or uphold certain orders or even make their own orders. And then the case is already messy as it is. I mean, in the opinion of a lot of people. So I think really the CJ was looking at the fact that, you know, let this matter continue with this judge. Now, do I agree that a matter should be put on hold, a criminal matter, an accused person is behind bars whilst a judge goes on a vacation? No, I don't. And I'm not going to be ashamed to say I don't. I do not agree with it. I don't, and I will never agree with it. The second bit that I do not agree with in that statement, in that response, was where the letter from the master of the High Court mentioned that, but the defense is free, they are at liberty to go and make the application before the High Court in Bundung. And if that is granted, then the CJ said he has no problems in issuing a fiat for the matter to be heard. Now, the problem with that statement is the fact that the Bundung High Court, the judge has already gone on holiday. The judge is not there. So who will the application be made to? Who will the application be made to? And secondly, Justice S.M. Jallow had already indicated that he has no appetite to allow a vacation judge to handle this matter. So making that application before the vacation judge, before Justice S.M. Jallow, is a futile exercise. It's a useless journey. So that was the bit that I did not quite understand in that response from the master of the High Court. But other than that, I really think it is even in Bob's favor that this matter should just continue with S.M. Jallow. If he has messed up anything, he will have to deal with the mess. If he hasn't, then so be it. And I know Bob is a patient guy. He's already waited this long. 2 months is not a long time to wait. 2 months is not a long time to wait. So this is my opinion on that. That I think this is what the CJ saw. Now, if you ask me, I would say that with everything that has gone on, the CJ should have reassigned this case to another judge. But then again, you also don't want to open the floodgates. Because what it would mean is that every single litigant or every accused person that has an issue with a particular judge would now go to the CJ and ask that the matter be reassigned. And that is not sustainable. And this is what I try to explain with the argument of the applicant in the bail hearing, where they're arguing on grounds of human rights. That it is not sustainable to give a ruling to that effect, because you're opening the floodgate, because everybody else will now say they shouldn't be in mile 2. They would start to claim their human rights. Now, if you take away, we all know what is going on. We all are not happy with Justice S.M. Jallow. I mean, anybody who says they're happy with S.M. Jallow when they are not, they will be lying. So me, I'm not going to lie and say I'm happy. I'm not happy with the way things have been going. But the fact is, you can't just go and ask that the matter be reassigned to another judge. If you do that, you're opening the floodgates, because somebody else would also come and have a reason where they would want the matter to be reassigned to another judge. Do we have enough judges to have that going on, where matters would just be reassigned because an application was made to that effect? So that is the problem we have. But we also have to keep in mind that everything that is going on in the lower court, if really it goes the way it is, those would be grounds for Bob's appeal, if at all he is convicted. And when it goes to the appellate court, trust me, that is not a one-man court. It is a panel. So people would look at things differently. Everything will come into scrutiny. So let us be patient. Let us be patient. We have come this far. I would say let us be patient. Let us respect. I mean, for me, I've always advocated, nobody would ever say they've ever seen me insult Justice S.M. Jallow. Nobody would ever tell you that they see me insult or caricature the Chief Justice. I would never do that in my lifetime. Nobody would say they would see me insult the Attorney General and Minister of Justice. No, I will never do that in my lifetime. I will not speak ill of them. I don't have the time to. What I will do is, I will speak my facts. I will say my opinion. But at the end of the day, we need to respect these individuals in the dispensation of justice. Because, to be honest, these people are humans too, and they feel. We might think this is social media and we have a right to do whatever and say whatever. But at the end of the day, we need to understand that these individuals, even though you call them judges, you call them Supreme Court judge, you call them High Court judge, you call them a Court of Appeal judge, they are human beings and they have feelings too. There are people who are on social media, maybe you don't see them. They have families who are on social media. The more you continue to insult them, the more you continue to do things to them, the person that feels the brunt is Bob. The person that feels the brunt is Senabu. It is not you and I. We can just sit here and open our big mouths and talk from thy kingdom, from morning till thy kingdom come. But at the end of the day, the individuals that would bear the brunt of our actions is the person who's behind bars. Is the person who's dependent on the system. Is the person his or her life are in the hands of these individuals. And that is why our pronouncements need to be measured. You can, for me, I always say this, you can attack on issues. You can attack on substance. But these are respected individuals that you don't caricature. I'm a lawyer. You think I'm mental? You think I'm mad to sit here and be caricaturing the CJ? I will never do that. There's nobody that can make me do that. You think somebody will share a post caricaturing the CJ and I come and I like that post or I share it? I will never do that in my lifetime. Never. Because we have to understand that in supporting a particular individual, we have to know that our actions sometimes have direct implications and or repercussions on the people we are supporting and or advocating for. We should always be mindful of that. biggest thing we can do for Bob, the biggest thing we can do is to advocate and show the world the biasness, show the world the loopholes, show the world the disability of our justice and judicial processes. This is what we can do. And this is the greatest thing we would do. It is the greatest service that we would give to Bob. We need to continue to advocate. We need to continue to let the world see and know and understand the reason why we are advocating for an overhaul of our justice delivery system. Caricaturing the CSJ or the Attorney General will not do nothing. It would add absolutely no value to Bob. Attacking state councils, it will add no value to Bob's case. Let us galvanize, let us use that energy, let us harness that energy in continuing to preach the message, in continuing to advocate for a justice delivery system that is fit for purpose, for a criminal justice system that is equal, for a criminal justice system that is transparent, it is fair, it is effective, and the justice dispensation is done in a very timely and effective manner. This is the best thing we can do. But you don't want to make your actions be detrimental on the person you're advocating for. Because let us always remember that social media is wide and broad. And let us always remember that these judges are humans and they feel. They're humans and they feel. So let us always ensure that as we advocate and we call for a free, speedy dispensation of justice for Bob Keita and all others who are languishing in jail, who are victims of this very same system. No, I did not say, I'm responding to Auntie Amina. I did not say we have to babysit our justice system. If I ever thought that we have to babysit our justice system, I would probably be in my bed right now. I'll be sleeping. But what I am saying is that ridiculing particular individuals does not tell well of us, and it does not add any single value to our fight for justice. This is what I am saying. We are all frustrated with the justice delivery system in the Gambia. But if you hear me speak, I continue to speak on the system. I don't talk about individuals. I don't pick on individuals because I know and understand that the system is bigger than any individual. I know and understand that the system is bigger than any individual. That individuals will come and go, but the system will remain. And that is why my advocacy is centered on the system. On the system, and not necessarily on individuals. Individuals will go. Individuals will find another job. Individuals will retire. Individuals will even die when they don't want to go. They will die when they don't want to go. God will call them home. But the system will remain. And therefore, let our advocacy, let our frustrations be directed at the system. At the system. Let our advocacy be blind. Let it not be a respecter of persons. It doesn't matter if it's Pate or Abdul or Modu or Lamin or Elizabeth or James. The system is fundamentally flawed. The system is fundamentally disabled. The system has enough loopholes that needs to be tidied up. The system has to be fit for purpose, and it has to be at par with what goes on in other progressive jurisdictions. So yes, individuals do make up the system, but the individuals are not the system. And that is why a country like America, they build the systems. They build the systems to a point when Donald Trump said that he was not going to leave office. The system was so strong. The system was so strong that he began to realize that the system was leaving him. So he would not have left office, but the system would have left him. And that is why we're advocating for strong system and strong institutions. And this is what Barack Obama said when he addressed the Ghanaian parliament. He said Africa must build strong institutions and not strong men. Because strong men will die off. Strong men will go. Strong men will change. But a strong system is there forever. And that is why when a president, if Donald Trump was in Gambia, or Donald Trump was in Nigeria, or Donald Trump was in another African country, he would not have left office. He would still be president. He would have still held on to power. But regardless of the power and strength of Donald Trump, the American system was stronger. The institutions were stronger. And therefore, when he realized that the office and the system and the institutions were leaving him, he had no choice but to pack up his things and go. So we need to advocate for strong systems and not strong men. Because when we have strong men, what will happen is they will pour hot water on us. They will use tear gas on us. They will use their batons on us. When you have strong men, they will buy and order water tanks. When you have strong men, they will not want to leave office. When you have strong men, they will circumvent the system. When you have strong men, they will use the system to continue to perpetuate. And that is why we should now advocate for the building of strong institutions and strong systems. Systems that are stronger than men. Systems that are so strong that men will not be able to use them, do not be able to manipulate the system to continue to oppress their fellow citizens. Anyways, that is my opinion. As everybody knows, I respect everybody's opinion, and we always disagree to agree. People have different perspective. We respect their perspective. I have my own perspective, and I hope you will respect my perspective. If I'm able to convince you to join me, voila. If I can't, that's what it is. But in the final analysis, we all hope and pray that someday, sometime, we will have a system in place that is no respecter of person. That regardless of race, creed, gender, ethnicity, social status, or whatever it is, the system will be right to all of us, and it will treat us equal till the end of time. I wish you all a blessed night. And mark my words. And I'm saying, as long as we have a system that is operational, and as long as we have a system that is workable, that is honest, that is sincere and true, a system that is no respecter of persons, there is no way that a ruling will be done that will grant Senawu and co bail. Because the very foundations of that bail application is the very reason why the bail of Bob was revoked at a higher court. A court whose rulings and judgments are binding on the lower court. So let's stay tuned and see how it goes. If the ruling goes my way, tag me and give me a heads up. If it goes your way, hallelujah. Good night and God bless.